What if I was hurt by a driver who came too close? Cycling accidents involving contact between the driver of the car and the cyclist are usually fairly straightforward in terms of the mechanism of how someone gets hurt, the relationship between the driving and the injury. The more difficult situations involved where the driver doesn't make contact with the rider. They cut them off, they, quote, run them off the road, or they simply come too close. And that brings in many situations, the whole thing about the 3 feet requirement in Florida. Most of us are familiar with the 3-foot rule, as it's called in Florida. But before we get into the answer to that part of the question, remember there are several statutes that require that the driver of a car, which in Florida is a dangerous instrumentality, has a duty to make sure they do everything to avoid imperiling a cyclist. Okay? It's written in several statutes in different ways. One of those is that they have an obligation when passing a cyclist to make sure they pass no closer than a reasonably safe distance, no closer than 3 feet. So what is a reasonably safe distance under the circumstances? That may vary. The question then becomes, if a vehicle comes within the 3 feet space, and as a result of that, the rider is startled or falls or gets injured, can they bring a claim against that driver? And the question the lawyer has to wrestle with is whether you can prove a direct relationship between the vehicle coming too close and the rider going down. So very few bright line situations. Most of this is shades of gray. So is it possible? Yes, it's possible. It's possible in a number of situations where there is no contact. But each case is going to be different, and the circumstances of what happened are very important.